Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma, Postgraduate Diploma in Criminal Justice, PGDCJ, MLE-014 Criminal Justice Administration, Block -1 Police, Unit-3 Custodial Violence, 3.1 Introduction. The custody of a person is procured under the criminal law in order to advance the criminal justice process against him, as the person concerned might be found as a suspect in some criminal offense. The custody might also be procured for crime prevention and due to some other reasons about which a clear provision is given in the law. The law gives specific powers to the police in case of arrest of a person and lays out norms which should be followed in case of arrest and detention. The human rights of individuals under custody are of prime concern because the person under custody becomes highly vulnerable to the abuse of power and authority of the individuals who are in the role of criminal justice functionaries. The police comes under frequent criticism for the violations of individual freedoms and abuse of authority and infliction of physical pain and psychological harms to those under custody. The police is accused of violations and violence in custody as it is not having any authority under law to use physical force on persons under custody. Torture is an extreme form of the use of coercive force and infliction of pain to persons under custody, which amounts to an absolute abuse of power which draws severe legal sanctions not only under domestic law but also under the international human rights law. The custodial violence in case of police has to be addressed most proactively because the police represents the state and the state represents the society. Therefore, abuse of authority by the police would amount to the breaking of law by the government, which would writ contempt of law, invite anarchy. It's primarily due to this reason that human right law addresses this issue with great responsibility. This unit addresses the custodial violence as an important area of police abuse of authority and discusses limitations to police powers. Through human rights, 3.2 objectives. After reading this unit, you would be able to times define custodial violence and torture, times evaluate the role and authority of police in arrest, detention and custody, times point out the limitations to the powers and authority of the police, times understand the human rights and legal provisions about custodial violence. 3.3 Custodial violence and torture. 3.3.1 Custodial violence. Prisoners and persons in custody have human rights, and custodial violence is the confession of the failure to do justice to living man. For a prisoner, all fundamental rights are an enforceable reality, though restricted by the fact of imprisonment. The issue of custodial violence is given prime importance in context of criminal justice administration because it concerns with the infringement of the natural rights of each individual to be free. Since police custody involves infringement of the freedom of movement, there is a need to be particular that the person under custody does not get into a situation where his other rights may also get infringed. This arises from a belief system that the convicts are also human beings and that the purpose of imprisonment is to reform them rather than to make them hardened criminals. No doubt, the police plays a vital role in safeguarding our life, liberty and freedoms. But the police must act properly, showing full respect to the human rights of the people, remembering that they are also beneath the law, not above it, and can be held liable for the violation of human rights. In fact, what the society needs is well-led, well-trained and well-disciplined force of police which help in protecting and promoting human rights. 3.3.2 Police custody. Full implications of custodial abuse can be seen by appreciating the meaning of the term custody and also noticing the difference between arrest and custody. The Code of Criminal Procedure 1973 by Section 41 prescribes the circumstances in which a police officer may arrest a person without a warrant. However, no definition of the term arrest is to be found in the code. Even then, it can be seen that the term arrest has a narrower ambit when compared to the term custody. Nevertheless, it is well settled that the custody of the police as contemplated by Section 27 of the Indian Evidence Act need to be a formal arrest but includes such state of affairs in which the accused can be said to have come into the hands of a police officer or can be said to have been under some sort of surveillance or restriction. Furthermore, the term police custody referred to in Section 26 of the Indian Evidence Act can't be construed in a strict or literal sense, as the term police custody would be that as soon as an accused or suspected person comes into the hands of a police officer, he is, in the absence of clear and unmistakable evidence to the contrary, no longer at liberty and is therefore in custody within the meaning of Section 26 of the Evidence Act. Even indirect control over the movements of suspects by the police would amount to police custody. 4.3.3 Torture. Torture is generally understood as systematic and deliberate infliction of acute pain in any form by one person on another in order to accomplish a desired purpose. The law enforcement agencies and the armed forces are generally accused of torture. According to international law, any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. In addition to state-sponsored torture, individuals or groups may inflict torture on others for similar reasons. Tortures may even derive sadistic gratification by inflicting torture. 3.3.4 Police duty and custodial violence. Police have a duty to protect the legitimate interests of the community by ensuring the safety and security of the people. In doing so, they will have to exert and enforce the authority of law strictly in accordance with the prescribed legal directions. At the same time, in achieving this delicate task, the police will also have to uphold the rights of all citizens, including those whose conduct come to their adverse notice as a part of that primary duty cast on them. A healthy balance is needed between the powers of the police to investigate offences as well as to bring offenders before the law, and the safeguards necessary for the protection of the legal rights of accused or suspected persons, the penal power of the state in the maintenance and enforcement of law and order as well as in the task of prevention of crime is exercised through its administrative apparatus of the police organization. The Code of Criminal Procedure 1973, the Indian Penal Code and the Police Acts have by law prescribed various tasks to be fulfilled by the law enforcing agencies. In order to faithfully discharge those legal obligations, the police will have to exercise the authority of law in pursuit of the constitutionally mandated legal goals. Apparently, a certain amount of use of force, minimum necessary in each case, is taken note of and provided for in these procedural and substantive criminal enactments, and also complementary arrangements contemplated in other penal laws as well. However, the misuse or abuse of that authority or the perversion of the legally accorded power by the law enforcers renders such issue beyond the pale of rule of law. 3.4 Custodial violations by police. Custodial torture has become a common phenomenon and a routine police practice of interrogation these days. It causes momentary public uproar, but once the incident fades away from the public, everything is forgotten. The term torture with reference to police custody implies infliction of severe pain or suffering, whether physical or mental, intentionally for the purpose of extracting from the person who is in police custody, or a third person, information or confession, or coercing or intimidating him or a third person to divulge the truth. It does not, however, include pain or suffering arising only from, inherent in or incidental to lawful sanctions. Torture has not been defined in the Constitution or any other penal laws. Torture of a human being by another human being is essentially an instrument to impose the will of the strong over the weak by suffering. The word torture today has become synonymous with the darker side of human civilization, and custodial violence, including torture and death in the lockup, strikes a blow at the rule of law. One of the causes of custodial deaths is the tremendous pressure on the police to detect cases whenever there is a surge in crime, and particularly heinous crime. It is the police who are singled out for blame. Unfortunately, many officers opt for rough and ready method for quick results. Subordinate officers who are entrusted with the job of applying third-degree methods overdo it. Custodial death often occurs not because of an intention to kill the victim, but as a result of excessive torture, or when quite unknowingly the officer injures some weak organ of the victim. 3.4.1 The justification given by the police. The police officials justify custodial torture as a necessary evil to keep growing crime rate under control. They justify and support use of violence and third-degree methods against apprehends criminals on the following grounds. 1. Professional and hardened criminals understand the language of violence only. They would not tell the truth unless sternly dealt with. 2. When these offenders have no respect and regard for the rights of innocent persons, i.e., victims, why should the police respect their rights? 3. If police deals with offenders politely and gently, no one would ever be prosecuted for his crime. Thus, from the practical point of view, rough and tough treatment with the criminals is inevitable. Whatever may be the justification for the institutionalization of custodial torture, the developing human rights jurisprudence demands that this dangerous practice should be eliminated completely. It is generally difficult in cases of death in police custody to secure evidence against policemen responsible for resorting to third-degree methods, since they are in charge of police station records, which they do not find difficulty to manipulate. It is only in few cases that some direct evidence is available. 3.4.2 Death in police custody. In its report, Torture in India 2008, A State of Denial, the first ever nationwide assessment on the use of torture in India, the Asian Center for Human Rights stated that 7,468 persons, at an average of 1,494 persons per year or about 4 persons per day, have died and or been killed in prison and police custody during 2002 to 2007. An equal number of persons, if not more, have been killed in the custody of the Army, Central Armed Forces and States paramilitary forces in insurgency-affected areas. A large number of these deaths are a result of torture, according to Section 176 CR.P.C. Whenever any person dies in police custody, a magisterial inquiry is done. Magistrate does the inquest, holds a detailed inquiry into the cause of the death, records the statements of the aggrieved party and the police, collects the relevant evidences and then submits its reports to the government in case the police is indicted in the magisterial inquiry action under appropriate section of law like Section 302 IPC, punishment or murder. Section 120B, punishment for criminal conspiracy, Section 218 IPC, punishment for public servant framing incorrect record, 201 I.P.C. punishment for causing disappearance of evidence of offense, etc. is taken, even otherwise also if a prima facie case of custodial death as a result of police torture is felt by the senior police officers. Sumoto a case against the erring police personnel under appropriate section is registered, and as per the process of law these personnel are arrested, sent to jail and dealt with. 3.4.3 Challenges before police and human rights norms. The police in India has to perform a difficult and delicate task in view of the deteriorating law and order situation, riots, political turmoil, student unrest, terrorist activities, increasing incidents of bribery, corruption, tax evasion, violation of fiscal laws, smuggling and money laundering. Organized criminal gangs are gaining strong roots in the society. They use ultramodern weaponry, explosives, and many other devices for committing crimes. Similarly, dealing with insurgent and terrorist groups is also completely different from dealing with ordinary criminals. This category of criminals is well-trained, hardened and equipped with ultramodern weapons. Indeed, a resourceful criminal can escape the clutches of law almost indefinitely. Moreover, the Indian police still finds itself handicapped on account of inadequate infrastructural support. In our country, we are accustomed to think in terms of an eye for an eye and tooth for a tooth. Therefore, the society tactically expects and approves of the use of violence and third-degree methods on the suspects to get the truth, more so if their personal interest is involved. Lack of proper motivation, overzealousness of investigating officers to ensure detection of cases by eliciting confession from the accused persons, and low morale of the members of the force are the main psychological reasons behind resorting to third degree as shortcut method of detection. Human rights norms are diagonally opposed to such justification of the pressure of detection of crime as under no condition infringement of individual liberty and life could be finished by any authority. 3.4.4 Some issues about police reforms. Apart from the legal provisions binding the police, there are certain issues of institutional reforms and practical job-oriented changes which can have a positive impact on improving the situation and making the police personnel more sensitive and accountable to the legal norms which already bind them. Sensitization and human rights training is a very important criteria to advance in making the police services more sensitive and humane in their approach towards persons in custody. The use of scientific methods of investigation in detection of a case calls for tremendous patience, tenacity and professional expertise. The use of scientific methods of investigation may at times be exhausting for investigating officers lacking proper orientation. Officers with low morale and suffering from a sense of deprivation may at times resort to custodial violence for deriving sadistic pleasures. Lack of infrastructural facilities in the police stations may also lead to such unfortunate incidences. Absence of separate female lockup in many police stations has made the detention unsafe for arrested women. The problem is further aggravated due to absence of sufficient number of women police officers at the police station. 3.5 Torture in custody and legal provisions. Custodial violence by police is a widespread problem in India. Both domestic law and international human rights instruments impose strict parameters for police's handling of persons in custody. The Supreme Court has been trying to protect the rights of victims through court decisions, yet torture and ill-treatment of persons in custody continue to pose a serious problem in India. Article 21 of the Constitution guarantees the right of personal liberty and thereby prohibits any inhuman, cruel or degrading treatment to any person whether he is a national or a foreigner. Any violation of this right attracts Article 14, which enshrines right to equality and equal protection of laws. Such rights are discussed in the International Covenant on Civil and Political Rights (ICCPR) as well. There are 3 provisions which cover rights of the arrestees, namely Articles 9, 10 and 11.2. Human dignity is a dear value of our Constitution and international human rights instruments, not to be bartered away for the mere apprehensions entertained by jail officials. Torture has not been specifically defined in the Indian Constitution or specifically prohibited in penal laws. However, the Supreme Court has held that the right not to be tortured is enshrined in the right to life guaranteed in Article 21 of the Constitution. Sections 330 and 331 of the Indian Penal Code (IPC) provide for punishment for voluntarily causing hurt to extort confession or to compel restoration of property, and Section 29 of the Indian Police Act 1861 provides for imprisonment not exceeding 3 months with or without hard labor for offences including unwarrantable personal violence to any person in his custody. However, these provisions are rarely used against police officials. The Supreme Court also went further to award compensation to victims of custodial violence who suffered physical and psychological torture and ordered prosecution of police officers responsible for such crimes. The National Human Rights Commission (NHRC) has also been making an effort to reduce the custodial violence by issuing a guideline that any incident of custodial death or rape must be informed to the NHRC within 24 hours of occurrence. Furthermore, the NHRC has directed the police, in a case of death in custody, to submit a post-mortem report and a chemical analysis report in order to prevent the police from distorting evidence relating to the death. Finally, it should be noted that despite earnest attempts by the Supreme Court to curb torture and deaths in custody, these crimes are still very prevalent in India. Thus, it is crucial for individuals to be aware of all their rights while in custody and to actively demand them. Some of the provisions related to custodial violence and police responsibilities could be ascertained through the tables given in this unit. 3.5.1 Constitution of Indian and Rights for the Protection of Individuals Under Arrest or Detention. The Constitution confers certain rights to individuals which help in protection against torture and other inhuman and degrading treatments. These constitutional provisions also bind the police and limit its abuse of powers. The following table gives brief description of these rights. 3.5.2 International Human Rights Provisions Against Torture. International provisions banning torture. The international human right law is strengthened through the International Treaty on Torture, the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment is the principal treaty setting standards for legal provisions and governmental actions against torture. In addition to these, International Covenant on Civil and Political Rights (ICCPR) is the fundamental treaty governing the civil and political rights of individuals across the world, and this human rights treaty is of primary importance for setting standards related to banning tortures. India is a signatory to ICCPR, also guards the human rights and sets sub-international standards for promotion and protection of freedom from torture. International NGOs like the Amnesty International, the Human Rights Watch, Article 19, Minority Rights International, Liberty are important international NGOs are working against Torture and abuse of authority law enforcement agencies. 3.5.3 Violations of ICCPR provisions. India is one of the few countries in the world whose constitution allows for preventive detention during peacetime without basic safeguards to protect fundamental human rights. Yet, India has ratified the ICCPR, which explicitly prescribes preventive detention. Article 4 of the ICCPR permits derogation from guaranteeing certain personal liberties during a state of emergency. However, the Indian government has not invoked this privilege, nor could it, as the current situation in India does not satisfy the standards set forth in Article 4. Nonetheless, preventive detention is an executive body. This results in excluding be reviewed by an advisory board, which too is an executive body. This results in excluding the judiciary from the decision-making process and contravenes a detainee's right to fair and public hearing and to appear before an independent and impartial tribunal under Article 14(1) of ICCPR. While India's laws and policies directly violate Article 9 of ICCPR, which bans arbitrary arrest or detention and requires the grounds of arrest to be communicated at the time of arrest, India had made a reservation to Article 9 of ICCPR, stating that this article will only be applied in consonance with the section of Article 22 of the Indian Constitution, Box 1. Custodial violence and third degree. The custodial violence is also popularly known as third degree. The term third degree has not got any legal justifications or procedural relevance, but over the time this term has been used widely to denote violent ways of interrogation and obtaining confessions. In police interrogation, originally torture, then colloquially an intensive rough interrogation to extract information or a confession. The term third degree brings an ironic reference to the Masonic ritual, which involves a symbolic, severe interrogation and beating. The classification of the qualities of objects by degree, heat, cold, moisture and dryness, etc. was commonplace in the Middle Ages. Henry Lvite's translation of Dodon's Knive Herbal or History of Plants, 1578, includes a description of roux. Roux is hot and dry in the third degree. Shakespeare went on to apply the degree classification to drink in Twelfth Night, 1601, for he is in the third degree of drink, he is drowny, go look after him. The present meaning involves more than classification though. The third degree is well known to all crime fiction enthusiasts as an intensive, possibly brutal, interrogation. In Masonic lodges there are 3 degrees of membership. The first is called Entered Apprentice, the second Fellowcraft, and the third is Master Mason. When a candidate receives the third degree in a Masonic lodge, he is subjected to some activities that involves an interrogation, and it is more physically challenging than the first 2 degrees. It is this interrogation that was the source of the name of the police force's interrogation technique. That is referred to in an 1900 edition of Everybody's Magazine. From time to time a prisoner claims to have had the third degree administered to him. North American Freemasons in the third degree swear, I will keep a worthy brother Master Mason's secrets inviolable when communicated to or received by me. In the parlance for police questioning, the theme has developed to combat the resistance conditioning of the source. Box 2. Supreme Court's directives for avoidance of custodial crimes. The Supreme Court has expressed its concern for custodial commission of crimes during investigation and interrogation and laid down certain principles to be followed by concerned police officers in its historic decision in D.K. Basu v. State of West Bengal. The basic requirements to be followed in all cases of arrest of detention till legal provisions are made in that behalf to prevent custodial violence are as follows. 1. The police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible and clear identification and nameplate with their designations. The particulars of all such police personnel who handle interrogation of the arrestee must be recorded in a register. 2. The police officer carrying out the arrest shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall also be countersigned by the arrestee and contain time and date of arrest. 3. A person who has been arrested or detained and being held in custody in a police station or interrogation or lockup shall be entitled to inform his friend, relative or a person having interest in his welfare as soon as practicable that he has been arrested and is being detained at a particular place, unless the attesting witness of the memo of arrest is himself such friend, relative. 4. The time, place of arrest and venue of custody of an arrestee must be notified by the police. 5. The person arrested must be made aware of his right to have someone informed of his arrest or detention as soon as he is put under arrest or is detained. 6. An entry must be made in the diary at the place of detention giving all details about the friend, relative or person informed. 7. The arrested should, where he so requests, be also examined at the time of arrest, and major and minor injuries, if any present on his/her body, must be recorded at that time. The inspection memo should be signed both by the arrestee and the police officer effecting arrest. 8. The arrestee should be subjected to medical examination by a trained doctor every 48 hours during his detention in custody. 9. Copies of all documents including memo of arrest should be sent to the nearest magistrate for his record. 10. The arrestee may be permitted to meet his lawyer during interrogation, but not throughout the interrogation. 11. A police control room should be provided at all district and state headquarters where information regarding the arrest and the place of custody of the arrestee shall be communicated by the officer causing the arrest within 12 hours of effecting the arrest, and this should be displayed on a conspicuous notice board at the police control room. The apex court opined that failure to comply with the above requirements will render the officer concerned liable to be punished or contempt of court besides the usual departmental action against him. The court noted that these directives would help to curb, if not totally eliminate, the use of questionable methods during interrogation and investigation leading to custodial violence. Box 3. Writ of habeas corpus. When a person is detained and if there is some reason to suspect that he or she is unsafe in custody or there are no legal grounds for the person's detention, one can file a petition with the appropriate High Court or the Supreme Court of India for a writ of habeas corpus. A writ of habeas corpus is an order from the court demanding that detaining officer present the detained person before the court and informs the court of the grounds of the confinement. If it is revealed that there are no lawful grounds for the detainment, the detainee should be released. Otherwise, the detention is sustained and the regular bail procedure should be followed. When the detainee is presented before the court by means of the habeas corpus writ, the court can also ascertain whether or not the detainee has been tortured or mistreated by the police or anyone else while in detention. A writ of habeas corpus can be filed either by the detained person or by a relative or friends on his or her behalf. The application for a writ of habeas corpus must be accompanied by report stating the circumstances of the imprisonment. A writ of habeas corpus need not be a formal document. It may be a letter or telegram to the court setting out the circumstance of the detention. The advantage of a telegram is that it is an officially timed and dated document. If the police later claims that the person was not arrested or were arrested at a later date, the telegram can effectively be used as evidence of the details of the detention. While there is no limitation period on petitioning the court for a writ of habeas corpus, the sooner the petition is lodged, the greater is its chances of success. When filing a writ, the petitioner should always keep a copy of the request for habeas corpus. The habeas corpus writ has long been used a method of preventing and discovering illegal detentions, and also as a vital checking mechanism to ensure that the detainee has not been abused. It provides an instant determination as to the legality of an existing detention and, if exercised, protects detainees from incommunicado and indefinite detention by unscrupulous police officers. For these reasons, it is important to be fully aware of the existence of and procedures relating to the exercise of the habeas corpus writ petition. Thank you. Subscribe to our channel for more updates, and we will see you with the next chapter.